Today we talk about the rights of medical scheme members. Now, the Medical Schemes Act is a piece of legislation that protects the consumer of medical schemes enormously. And I hope after this video that you will agree with me that the rights of consumers are well protected in terms of the Medical Schemes Act. So there are 10 key principles that I first want to address in terms of the Medical Schemes Act. The first one is that there is open enrollment. Now what that means is that anybody can join a medical scheme. Doesn't matter how ill you are, how old you are. In fact, we have today people joining medical schemes that's older than 100 years old that still join a medical scheme. You also have continuation of membership. Now, what that means is that if you are dependent on your spouse's medical scheme and your spouse would pass away, the medical scheme must keep you on that medical scheme, providing that you pay the contributions. The next key principle that is enshrined in our Medical Schemes Act is community rating. Now, basically what that means is that the young pays for the old. The old are subsidized by the younger population. The healthier people subsidize the more ill people of the population. Now that doesn't make sense because we are told in insurance that you pay a premium for the risk that you pose to the insurer. Now with the Medical Schemes Act, we applied that principle where you cross-subsidize, and we call that community rating. So it means everybody, doesn't matter how old you are, how ill you are, on the same option of a medical scheme, you will all pay the same contributions. There's just a few penalties or late joiner penalties that the medical scheme can impose, and they can only impose it in certain circumstances. And that is limited, and they can waive the late joiner penalty, but they can only, or they're not allowed to impose a higher penalty than what the Medical Schemes Act provides for. The next aspect is waiting periods. Now, there's only 2 waiting periods that medical schemes can impose, and we have a video that specifically deals with this aspect in more detail. But there's a general waiting period, easy to understand. It is a 3-month waiting period that you belong to a medical scheme, but you cannot claim. And then in certain circumstances, you do have access to prescribed minimum benefits. And the other waiting period is a 12-month condition-specific waiting period. Now, that's for a specific condition for which you have sought care, treatment, or diagnosis in the 12 months ending on the date of application. Then, doesn't matter which medical scheme option you join, the most expensive option or even a cheap option, a very affordable option, a medical scheme must provide certain prescribed minimum benefits, a certain set of benefits that covers everybody at cost on all options. And then there's certain requirements in terms of managed care. Medical schemes do have a right to manage the risk and impose certain rules to manage that risk. The Act allows that. But in that, the Act also says that if there is a conflict between the medical scheme and the provider, that doesn't absolve the member of certain rights in terms of managed care. And there's certain other aspects in terms of managed care, like evidence-based medicine, how that is dealt with. And in a section that we deal with PMBs, and there's a specific video on that, we actually speak about the rights of enshrined in the managed care principles, where substitution must be made, where evidence-based medicine must be applied. And we explain in that specific video how that rights are enforced. Medical schemes also have certain governance principles where there must be an arm's length transaction between the administrator and the medical scheme. The medical scheme must be able to make their own decisions about the affairs of the members of the medical scheme. And then certain people are not allowed to be a member of the board of trustees. People such as brokers, managed care organization employees, or the administrator of a medical scheme. They cannot be trustees of that medical scheme. And that's for good reason that that is provided. Medical schemes must also have certain financial soundness and a certain level of reserves. We call it in our industry solvency. And that is there to protect members of medical schemes so that the scheme can fulfill their obligation towards the members to pay claims. And then the last principle is that intermediaries are accepted as a key ingredient of our healthcare system in guiding, educating, and protecting the member of a medical scheme. So, the rights. Now, all the key principles, the 10 principles, are also rights. But there's some other rights that I want to focus on. And that is that a medical scheme can ask for a medical report when you apply. But I can only ask for a medical report for where you have sought care, treatment, or diagnosis in the 12 months prior to date of application. And should they ask for that, they must pay the bill for that account. There's also requirements in terms of payment of claims, where you have a right to receive payment within 30 days of a claim being submitted. Or a medical scheme must then, in that 30 days, dispute the claim and give you opportunity to then rectify that specific claim. You have a right to confidentiality. The POPI Act, the Medical Schemes Act, the Constitution, all those pieces of legislation protect the confidentiality of an individual. We must remember that when you claim, that is private information. It's information available to you and the people that you choose to share it with, and your medical practitioner. But now the medical scheme sits with this information. They cannot share that with your employer or with the intermediary. The intermediary needs to be authorized by you to receive that information. And another right, and I've alluded to that in the previous slide, is that where the medication is ineffective cause or would cause harm, or the protocol is ineffective cause or would cause harm, appropriate substitution must be made to that beneficiary. Now, that doesn't mean, and some of these expenses are high when they substitute it, and it's a huge financial burden on the medical scheme, but that doesn't mean that they have to provide it to everybody. But in that specific beneficiary's example, they have to then provide those benefits. And you also have a right to complain. If you are unhappy with a decision that the medical scheme took, you can then complain to the dispute committee, or you can also appeal it to the Council for Medical Schemes. And then, as I mentioned, all the 10 key principles are also rights. But with every right also comes obligations. So what are the duties of medical scheme members? We have to pay our contributions. We have to pay the contributions on time. Usually it is within 3 days of the beginning of the month. If the contributions is in arrears, it is 3 days in the new month. You have to repay a debt that you owe to the scheme. So if you owe the scheme a certain amount of money, that a claim has been paid that shouldn't have been paid, that creates a debt, and you have to repay that debt to a medical scheme. You should act honestly and not submit fraudulent claims. Now, that's a duty that we have as citizens. But in terms of the Medical Schemes Act, that is very important, because remember, money that is paid out is not a medical scheme's money. It is actually the members of that medical scheme. It's their money. And for that reason, there's a additional burden placed on members not to submit fraudulent claims. You shouldn't commit a fraudulent act, i.e. claim for a child that is not covered. You've got 3 children, but you only cover 1 child on the medical scheme, and then you take that specific child to the doctor because that child is ill. Now, that's a criminal offense. All these offenses, or honesty, dishonesty, fraudulent claims, are all criminal offenses. But also, you are defrauding actually members of medical schemes if you were to make yourself guilty on that. So that is a duty that is imposed on medical scheme members, that we should not do that. And then when you apply to a medical scheme, you need to disclose all material information to the medical scheme. And for us, that is a very important aspect. Now, sometimes people are scared to disclose all the ailments because they're scared that a waiting period will be imposed. But remember, there's only specific waiting periods that can be imposed. So if you had a back operation, let's say 15 years ago, or you had cancer 5 years ago and is in remission and don't receive care, treatment, or diagnosis in the last 12 months prior to date of application, no waiting period can be imposed on you. But if you do not mention or disclose those information to a medical scheme, the medical scheme can then, and they can, if you contravene any one of these 5, can then terminate your membership of that medical scheme. So disclosure is always important. Rather disclose more than less. How can you find more information? You can find more information on the Facebook page, Medical Schemes Explained. You can also find it on the website, medicalschemesexplained.co.za, or you can also purchase the book Medical Schemes Explained on the website. You can either purchase an ebook or you can purchase a printed copy of the book. Thank you.